Justice Alito?
Just out of just out of curiosity, did this prison shave the heads of all of the prisoners?
As I understand it, yes, that was the rule.
They shaved the heads. They didn't allow any type of, even a short haircut.
I guess I can't speak to the length, but as I understand it, the rule across the board was everybody who comes in gets their haircut. And I think it's really the paradigmatic example of the kind of inflexible and unyielding rule that Congress, in enacting this statute, was trying to get states to stop if they wanted to accept federal funds, that they needed to accommodate religious liberty.
If the language of RLUIPA was not clear enough to abrogate sovereign immunity in Sosamon, why is it clear enough to satisfy the spending clause?
I think it's really two answers. The first is, as Tanzin explained, and this court has said many times, you always understand text in context. And the context of what's appropriate in a suit against a sovereign is very different than the context of what's available against an individual. This court said this in Sosamon. It also said it in Tanzin. The tradition as to a sovereign, of course, is you don't get damages, but as to an individual, this is a tradition that runs all the way back to the founding. I mean, damages have always been available in that context. And so I think the context is probably the clearest answer. I think there's also some suggestion, if you compare Franklin and Sosamon, that the clear notice standard on the spending side is not as demanding as the sovereign immunity, but I think you don't need to get into that because the contextual difference is so clear.
Well, why